The first sign that something was wrong was a letter I received on an ordinary Tuesday morning. It said I was no longer the legal owner of my ranch. I actually laughed when I read it. My ranch had been in my family for decades. I had the deed. I paid the property taxes. I maintained every fence, every access road, and every acre myself. There was no way I had somehow sold it without knowing. But then I checked the county property records. My name was gone. Someone else was listed as the owner. And the transfer document looked official. Almost. There was only one problem. I had never signed it. I immediately contacted the county recorder's office and requested a certified copy of the deed. When I saw it, my stomach dropped. The signature looked like mine. But it wasn't. Someone had forged my name, and the buyer was connected to the HOA. That was when everything started making sense. For months, the HOA president, Karen Mitchell, had been pressuring me to sell part of the ranch. She claimed my property was becoming an eyesore. She complained about my private access road. She even suggested that the HOA could help simplify things if I transferred some of the land to them. I refused every time. Now, suddenly, my entire ranch had supposedly been sold. I called Karen. She answered almost immediately. I asked her if she knew anything about the property transfer. There was a long silence. Then she said something I'll never forget. "You should probably speak with the new owner." She hung up. That response told me everything. I contacted an attorney and provided copies of the original deed, tax records, property maps, and a suspicious transfer document. My attorney immediately recommended that we notify the county and challenge the fraudulent transfer. But I wasn't going to stop there. I wanted to know who had created the fake deed. So we started following the paperwork. The document had been submitted through a title company. The notary information looked legitimate. The signatures looked convincing. But when investigators checked the details, inconsistencies began appearing everywhere. The notary had never met me. The supposed signing date was a day when I was hundreds of miles away, and the witness information didn't match the county's records. Then we discovered something even bigger. The buyer had already started marketing part of my ranch for development. There were preliminary plans for roads, luxury homes, and a private clubhouse. Someone had apparently expected the fraudulent transfer to go unnoticed. They had made one huge mistake. They underestimated how carefully I kept my records. Every property document from my family was stored in multiple locations. I had the original deed. I had old surveys. I had tax receipts going back years. And I had photographs proving continuous possession of the property. The case quickly moved beyond a simple property dispute. It became an investigation into suspected document fraud and an allegedly fraudulent transfer. Then came the moment that changed everything. My wife walked into the room. Her name was Laura, and she wasn't just my wife. She was a federal judge. She had spent years handling complex federal cases. When I told her what had happened, she immediately reminded me of something important. She could not personally handle my case. She could not investigate it. She could not influence another judge. And she absolutely could not use her position to help me win. Everything had to remain independent. But there was something she could do. She could recuse herself from anything involving me and ensure the matter was handled by the proper court and judge. That's exactly what happened. The case was assigned to another judge. Investigators examined the disputed deed, the notary records, the title documents, and the people involved in the transaction. And then the evidence started coming together. One document contradicted another. A signature expert questioned the authenticity of the signature. The notary records raised additional concerns. And the alleged buyer couldn't explain why the transaction had moved forward so quickly. Then investigators uncovered communications between several people connected to the HOA. Messages discussing my ranch before the fraudulent transfer had even been recorded. That was the turning point. The court issued an order preventing any further sale or development of property while the ownership dispute was resolved. The development plan stopped. The contractors left. The signs advertising future properties disappeared. And the ranch went quiet again. At the final hearing, the evidence was presented piece by piece. My original deed, the certified property records, the disputed transfer, The notary inconsistencies, the timeline, the communications. Everything told the same story. The transfer was not legitimate. The court restored my ownership of the ranch. The people responsible for fraudulent documents were referred for further investigation, and the HOA faced serious legal consequences for its alleged involvement. Karen's confidence disappeared completely. The same woman who had once told me to speak with the new owner was now sitting silently across the courtroom. But the most important lesson came from my wife. After everything was over, Laura told me something I'll never forget. Justice isn't about who you know. It's about what the evidence proves. She never touched my case. She never called a prosecutor. She never pressured another judge. She simply followed the rules that protected the integrity of the court. And that's what made the outcome even more powerful. My ranch wasn't saved because my wife was a federal judge. It was saved because the forged documents couldn't survive a serious examination of the evidence. The HOA thought a fake signature could erase decades of ownership. They were wrong, because you can forge a document. You can manipulate a record. You can even convince people for a while. But eventually, the truth has to survive the paperwork. And in my case, it did